Minister.
Mr. Speaker, sir, I thank the members who spoke in support of the bill, and let me address the questions now. First, on the protocols for proceedings via video link. Mr. Louis Ng asked whether the way that live video proceedings are conducted can be standardized. He mentioned the need to maintain the security and integrity of court proceedings. The specific ways for participation in remote hearings are published in registrar's circulars and set out in courts' websites. The specific protocol that applies may vary, depending, for example, on the type of case and the litigants involved. On the security and integrity of proceedings, the courts have protocols in place. We will take the point and emphasize to the courts. Mr. Murali Pillai asked how conversations between accused persons in prison and their counsel joining in from another location will be kept confidential, and how accused persons will continue to have access to lawyers during remote proceedings. The Prison Service, Singapore Prison Service, SPS, has a purpose-built video link facility or set of facilities. And in the course of a remote hearing over Zoom or telepresence, SPS will facilitate the private consultation sessions between the accused persons and their lawyers. And these can be done through the telephone, a virtual breakout room on Zoom, or a separate cubicle with Zoom session between the accused person and his lawyer. Mr. Desmond Chu expressed concern with the rise of deepfake technology and the impersonation of parties or witnesses. The actions mentioned by Mr. Chu are, of course, criminal offenses. In terms of safeguards, the courts are considering adopting new identification technologies, and they are planning for them under the National Digital Identity Project. Ms. Honey So, proposed the creation of a virtual court platform with an integrated chat function, dynamic queue system, and she explained the benefits of it. The courts are working on several improvements aligned with Ms. So's suggestions. First, there will be a new queue management system. It will allow the judge to resequence the parties according to some specified criteria. There may also be a forecast of the number of cases which are pending, which can be made visible to all. Second, the courts are also enhancing the SG Courts app to allow for formal on-the-record discussions between the lawyers and the court. Ms. So has also asked about assistance schemes for smaller law firms to defray the cost of purchasing virtual hearing equipment. She has also asked whether filing fees can be reviewed and whether the courts are able to provide more spaces for practitioners to communicate with their clients in person. She did mention, MinLaw has been working on initiatives to help law firms, especially the smaller ones, ramp up their use of technology. These efforts include the Techcelerate for Law, the Tech Start for Law, and as Ms. So pointed out, we will build on these to further help law firms adopt technology and transit to remote hearings. This will also help with their transition onto the electronic court systems. A major initiative that law firms can look forward to would be a legal tech platform which will enable, in an affordable way, law practices and lawyers to work anytime, anywhere. This is a matters management tool designed specifically around legal workflows. My ministry is actively working on this. The platform, we aim to integrate it with commonly used technology solutions like practice management solutions, document management solutions, communications tools like WhatsApp and Microsoft Teams, and government systems like LawNet, e-litigation, and ACRA, that lawyers commonly interact with. This platform will be a one-stop shop to help lawyers access key functions from such solutions and systems more seamlessly. We aim to introduce the platform to the industry in phases starting from the first quarter of 2022. We're also putting together an industry digital plan which will provide a step-by-step guide for lawyers to assess their own digital readiness and provide information on the technology solutions commonly used by lawyers, which will be mapped to the different stages of digital maturity. The industry digital plan will be launched in tandem with the legal technology platform. On Ms. So's question about defraying hardware costs, generally the government doesn't favor any particular group, say lawyers and so on, to buy equipment for their practices. But we made an exception last year because of COVID. So we worked to provide 80% funding support for all SMEs, including law firms, to procure laptops and commonly used software, such as Microsoft Office. On the provision of physical space, there are already many spaces within existing courthouses which lawyers can utilize to meet with their clients. And as for filing fees, we agree filing fees should be reasonable. We will pass the feedback on to the courts. Moving on to paper hearings, Mr. Zulkarnain Rahim sought clarifications on paper hearings, so let me take each of his questions in turn. First, whether parties can opt in for paper hearings. If parties prefer the matter to be heard on paper, they can inform the court, and the court ultimately has the final say, but it will take this into account when considering whether to proceed with a paper hearing. Second, on the benefits of paper hearings, it obviously saves costs and time, provided the matter can be dealt with through a paper hearing. And third, Mr. Zul asked whether there can be a fast track for the case management of paper hearings. That really has got to depend on each case, its nature, its complexity, and how prepared parties are for the speedier management of the case. And fourth, Mr. Zul asked about paper hearings in criminal proceedings. Well, in the context of remote hearings, Mr. Sharrell also underscored the need to be mindful of the human aspect in criminal matters. So we have to make sure the use of paper or asynchronous hearings not undermine the accused's right to be heard. So this bill protects the accused's right to be heard. The courts will exercise discretion to conduct paper or asynchronous hearings judicially. Mr. Pillay also raised a query on how the courts will ensure that litigants and persons are not disadvantaged by remote or paper hearings. Litigants and persons who have concerns with the using of remote technology or with a paper hearing can notify the courts. LIPs will be encouraged to take advantage of remote or paper hearing processes, but ultimately it is an option for them. If a litigant does not have the equipment or internet connectivity, he can of course come to court to use in-court facilities that do cater for remote hearings. The courts have published detailed guidelines on the conduct of remote hearings. The users may also reach out to the courts to get help. Ms. Shahira mentioned under the amendments to the Administration of Justice Protection Act, litigants and lawyers will now be prohibited from making their own non-official audio transcripts of court proceedings. The amendments under this bill do not change the underlying position today. Today, it's already contempt of court to record proceedings, physical court proceedings. So the amendments simply update the provision so that unauthorized recordings of remote court proceedings will likewise be in contempt. Mr. Louison asked a number of questions. One, on the scope of the court's powers to order parties to attempt amicable resolution. An attempted amicable resolution may be appropriate where the strict legal remedies may not necessarily address the underlying concerns and interests of the parties. or where litigation is not cost effective. Second, where parties have gone through formal processes such as mediation, neutral evaluation, settlement negotiations with exchange of draft settlement agreements. These are all likely to constitute clear attempts at amicable resolution. Third, Mr. Louis Ng asked how the court will ensure that the parties will make good faith attempts at amicable resolution, and what would be the consequences of non-compliance with the court's direction to attempt such amicable resolution. Mr. Desmond Chu also sought clarification on whether the court will consider the intention of the parties before exercising the powers. Well, the short answer to Mr. Ng's question is that it's not easy to ensure good faith negotiations. But in deciding whether to order parties to attempt amicable resolution, the courts will take into account all the facts before them, including whether any of the parties have refused to attempt to resolve the dispute by amicable resolution and why. And where necessary, the courts may require the parties or their counsel to explain why the matter cannot be settled amicably. Mr. Louis Ng asked whether registrars will be required to undergo training in mediation and other alternate dispute resolution processes, ADR, and whether there will be a minimum requirement that must be met and who the court-appointed mediators will be. In the state courts, mediation may be conducted by specially trained district judges or court volunteer mediators. The district judges are experienced trial judges. They have extensive experience in mediation and other ADR processes, and they undergo continuous training in ADR. As for court volunteer mediators, they must minimally be an associate mediator with the Singapore Mediation Center with at least 3 years of mediation experience. Alternatively, they should minimally hold a Level 3 qualification as a Singapore International Mediation Institute accredited mediator. For the Supreme Court, a registrar conducting ADR or a court-appointed mediator will similarly be trained in the particular ADR processes. Mr. Ng asked if there are plans to set up an equivalent of the state court's court dispute resolution cluster in the Supreme Court. Given the nature of the disputes and the value of the claims filed in the Supreme Court, there are no immediate plans to do so. Lastly, on Mr. Ng's question on how MinLaw supports the growth of private mediation service providers, MinLaw's role is to ensure a conducive environment for our dispute resolution ecosystem to thrive. We work closely with mediation service providers, such as the Singapore Mediation Center, the Singapore International Mediation Center, and so on, to ensure that their service offerings address the different user needs and complement the court-based dispute resolution mechanisms. We also have the Singapore International Mediation Institute, SIMI. It looks at accreditation and mediation standards to support professionalizing mediation. Mr. Zul asked about security for cost in the context of an application for freestanding interim relief. A defendant may apply for security for the defendant's cost of the action on the basis that the applicant has no nexus or assets in Singapore. On vessel arrests, these fall outside the scope of freestanding interim relief that the General Division can grant. This is consistent with the UK position. Mr. Zul sought clarification regarding the SICC's jurisdiction, the Singapore International Commercial Court. He asked when the action and the counterclaim taken as a whole would still maintain an international and commercial character. The assessment cannot be a purely quantitative one. The court will have to consider all the relevant facts and circumstances, assess whether the counterclaim, third-party proceedings change the nature or substance of the action in such a way that the action taken as a whole, seen as a whole, no longer maintains an international or commercial nature. Mr. Zul also asked about the consolidation of proceedings under the SICC and whether similar considerations would apply if one proceeding is in a different court from the SICC. The consolidation of proceedings under the SICC may require different considerations as parties would have already commenced separate proceedings. If proceedings are not before the same court, but a party believes that an application for consolidation is necessary, then a transfer application should be taken out to bring the proceedings before the same court before applying for any consolidation. Mr. Zul also pointed out on the joinder of a non-consenting party to SICC proceedings and spoke about the enforcement of SICC's judgment in a foreign jurisdiction. It is possible for a party to be joined to existing proceedings before the SICC without that party's consent, just like it is possible for a party to be joined to existing proceedings before the High Court or the state courts without that party's consent. There are rules on how that takes place. But of course, the requirements for proper service on that party will still apply. And with regard to enforcement, the enforcement of a SICC judgment against a party who has been properly served but is not submitted to the SICC's jurisdiction will be similar to the enforcement of a judgment issued by the General Division of the High Court against a party that is not submitted to the jurisdiction of the General Division. As with any judgment of the General Division of the High Court, an SICC judgment is likely to be enforceable in major commercial jurisdictions and many other regional ones. There are standard laws on how this takes place. Mr. Pritam Singh, Ms. Abdullah, and Mr. Zul and Mr. Pillai have raised a number of queries regarding the Attorney General's right to intervene. Let me make some broad points before addressing the specific queries. First, as my colleague, Minister Edwin Tong, mentioned in Parliament yesterday, the statutory framework is based on the established role of the Attorney General. He is the guardian of the public interest. This has been recognized by our courts as well as by members who have spoken on this bill and previously. So the proposed amendments are consistent with that principle. The Court of Appeal, for example, has noted that the AG intervenes on a non-partisan basis. He is disinterested in the interests of the parties to the litigation. The issues that he raises most logically must have a discernible impact beyond the specific parties and the specific dispute before the court. Second, it is important to understand the context in which this proposal arises. Let's say you have a civil case between two parties. Prima facie, nothing to do with the state or the public. But in the course of the dispute, or from the pleadings, or in the course of the arguments, issues arise which potentially are detrimental to the public interest. For example, the AG has intervened on the applicable legal test for negligence in relation to the provision of medical advice in the case of Hee Chi Kok and Wee Peng Jin between two parties, but the test that is laid out by the courts on what amounts to negligence will impact on future claimants on the basis of medical negligence. So it will impact both patients and doctors. And they can't come forward and intervene in this case. The only party who can do so in public interest is the Attorney General. So this relates to the provision of medical advice. You take another example. AG has intervened on the nature and scope of professional and ethical duties. For example, in Deepak Sharma and Law Society of Singapore, on what duties are owed by lawyers in making claims for costs. So in such cases, it is sensible, obvious that the AG must have a right to intervene to protect the public interest and put forward arguments. And ultimately, of course, it is up to the courts to decide on the validity of the arguments. So the amendments provide for the right of the AG to intervene for that purpose. But ultimately, the court decides on the merits of the substantive case, and the AG's presence assists the court and also informs the court of the possible broader implications and public interest. Third, the AG's application to intervene is only an intermediate step in the dispute. There is a two-stage process, broadly. The first stage, the court will check to ensure that the AG has set out adequate details, the basis, grounds for his request to be added as a party. Only if the court is satisfied that the AG has explained the reasons for his intervention sufficiently, then the court will grant permission for the AG to intervene. Of course, that's prima facie. If anyone wishes to oppose the AG's intervention, then they may apply to set aside the court's permission. And this brings us to the second stage, which will involve the AG and the other parties, because the first stage is ex parte. At this stage, the parties can raise any concerns they might have about the AG's addition to the proceedings. If any party objects to the intervention, the court will assess whether the permission that has been granted to the AG should now be reversed. And the court's assessment will be made based on the interests of justice. It can take into account and balance various considerations, including the possible inconvenience, cost to a party if AG is added, the potential benefits if AG is allowed to join the proceedings to add his perspectives on the matter. And any court will proceed, on the basis that the Attorney General is a guardian of public interest. And if he comes to court and says there is an important matter of public interest here, it's generally not assumed that the AG is being frivolous. There must be a serious point, and it's a matter of public interest. When someone comes in, particularly the Attorney General, to put forward arguments, the court knows that it will be of tremendous assistance to the court. Whether ultimately it decides how it decides, it's for the court, but the court gets tremendous assistance from the Attorney General. Mr. Singh asked if this is a shift in the common law position, and he's asked, why not we just stick with the existing position? Why do we need a new framework? The common law position does allow AG to intervene. For example, in the case of ARW and Controller of Income Tax, the appellant was a private company, applied for specific discovery internal documents belonging to IRAS. So this is a taxpayer, I believe, who sought documents from IRAS. But it goes beyond that to a broader principle of when you can apply for documents against a government agency. Whether it should be allowed or it should not be allowed is a matter for the court. Whether such a principle should apply to all public departments in the context of a private civil dispute, albeit against IRAS, is a matter of public interest. And the AG should be entitled to put forward his position, why it is or it is not in the public interest to make a particular order. And then it is for the courts to decide. So the AG applied to intervene to make representations on the issue of public interest privilege under the Evidence Act. Application for intervention was filed in the High Court. The company resisted the application. There was dispute on the addition of the AG to proceedings. It was resolved by the Court of Appeal 20 months later. The Court of Appeal allowed the AG to intervene, affirmed the AG's position as guardian of public interest, and it further held that if the AG does not intervene, despite taking the view that there are issues of public interest, then the AG would in fact be in dereliction of his public duty. All that is good, but 20 months had been lost. But taking into account what the Court of Appeal had said and the fact that you don't want these things to be unnecessarily delayed, I will say this to members. As in the cases cited, parties to a civil litigation are often seeking to interpret the rules in their own favor. If they succeed, sometimes it is a man in the street who will pay the bill, ultimately, if it's against public interest. So the AG is intervening to protect the man in the street, the common man. So we are moving to enact a clear statutory framework for the AG's right to intervene to lend certainty to this area of law, so that parties can proceed expeditiously to the substantive issues in the case. As I said, the addition of AG to the proceedings is a procedural step. It does not mean that either of the original parties has somehow lost or won the original lawsuit, though I can understand they may not like what the AG is going to say, and in that sense, they would prefer if the AG is not present, but that's not the way hearings and arguments should go. Mr. Singh has cited various statutes which expressly provide for the AG's right to intervene, Charities Act, Industrial Relations Act, and he is right, and in those pieces of legislation, the AG has an unqualified entitlement to intervene in the specified categories of proceedings. It's broadly similar principles, but unqualified. Here, the proposal is that even the addition itself, the parties can oppose if they wish. And then the court has got to decide after hearing both sides. Let me now turn to some of the specific queries. Mr. Pillay had a suggestion that the AG's role as guardian of the public interest be codified in the Constitution. As mentioned, the AG's role as guardian of the public interest has been affirmed by the Court of Appeal in a number of cases. It has also been recognized by this House today by Mr. Pillai and Mr. Singh. My ministry will study this suggestion, whether we should put it in the Constitution, the AG's established role in this respect, taking into account how this area of law and the jurisprudence develops. Mr. Singh asked if the amendments are intended as a contingency or whether there are new areas of public interest that the government is concerned about. So I'm not sure what Mr. Singh is concerned about, or that we always think ahead and planning something else that he is concerned about. The short answer is the amendments say what they say on the face of it. They are meant to lend clarity to the procedure for the AG to intervene and to minimize satellite litigation delays. But, it's not going to be possible to predict how other areas of law in which such intervention may be required in the future might take place, and what questions of public interest may arise will depend on the facts and circumstances of each case. Mr. Zul also asked whether there will still be a need for AG to intervene if a party to the proceedings can put forth an opposing view to the court. The AG's role is not to put forward supporting or opposing view, but to represent the public interest and what, in his view, is best stated in terms of public interest. Whereas the views of parties to the proceedings will obviously be influenced by their respective interests, and sometimes they cannot be a substitute for the non-partisan views of the Attorney General. The parties to a civil litigation are not there to advance public interest. They are there to advance or put forward their own case. Sometimes it is necessary that somebody else is there to protect public interest. Mr. Zul also asked whether the court can instead invite the AG to make submissions as an independent counsel under the Legal Profession Act. The role of an independent counsel is to address the court on specific issues of law at the invitation of the court, whereas the AG's submissions on issues of public interest may well go beyond specific issues of law. And unlike an independent counsel, the AG will be deemed a party to the proceedings if he is added on, and when he intervenes as a guardian of public interest. And so, like other parties, he will be able to make applications, file affidavits, and will also have the right of appeal. Mr. Pillai asked whether the AG has a duty of full and frank disclosure, since he will be making an ex parte application when applying for permission of the court to intervene. The AG will have a duty to disclose properly his grounds for intervention to the court. Ms. Shahira asked who should bear the costs where the parties choose not to appeal the court's decision, but the AG decides to do so. These are properly the matters for courts. Though courts generally understand that the AG doesn't act frivolously, vexatiously, egregiously in pursuing public interest, but ultimately it's a matter of discretion for the courts. Mr. Sharrell and Ms. Shahira spoke in support of the terminology amendments. Laws must be clear and easy to understand. The new rules of court will contain a clear list of definitions up front. Ms. Shahira highlighted the differences in terminology amendments that will apply across the courts and said that this might cause confusion. For the FJC, the rules are being reviewed and will be revamped in due course. The terminology changes will be effected with that revamp, and the majority of which are aligned with other courts. However, because of the unique nature of family proceedings, some terminology amendments will be specific to the FJC. For example, the terminology of parties in a divorce, the naming of parties as applicants and respondents, and is intended to avoid calling them claimants and defendants. Calling someone a defendant sometimes could be seen as pejorative. So this is really in line with FJC's move towards therapeutic justice. For the SICC, the differences are relatively limited. They generally relate only to two items. These differences arise as a result of the differences in court procedure in the SICC and the General Division. The procedure in the SICC is specifically tailored to facilitate international commercial litigation. We therefore do not think that this will give rise to confusion, since the respective rules of court will make clear the procedures that should be used. On the issues of legal representation, public education, building a world-class legal system, these issues raised by Ms. Sharrell, these are issues which my ministry is working on. And I would say our legal system is generally highly regarded. That, sir, brings me to the end of my responses to the questions raised. I believe I've answered all the questions raised by members, and with that, I beg to move, sir.
Clarifications? Hello, Mr. Pritam Singh.
Thank you, Mr. Speaker. Thank you, Minister, for addressing some aspects of the speech I made on this bill. Minister, my fundamental interest was to try and understand whether the common law position would actually change with regard to the two-stage process. I was listening very carefully to Minister Edwin Tong's speech at the second reading, and when Minister Edwin went through the various clauses that pertain to Part 4 of the bill, insofar as Part 4A4 was concerned, it reads in the explanatory statement, in considering whether to grant permission to intervene, the court need only be satisfied that the grounds for intervention are adequately set out in the affidavit. The court is not to examine the merits of those grounds, full stop. But Minister added in his speech, at that stage. So it suggested to me that my concerns about at what point the merits of the AG's arguments would be assessed by the courts is a matter of some query that I have, and let me go into the specific query. So, for example, at paragraph 56 of Deepak Sharma, the Court of Appeal noted that if the court takes the view that the issues that the AG raised do not pertain to the public interest, it is open to the court to refuse the course order in favor of the AG, even if the AG considers his intervention and submissions were warranted in the public interest. Now, although this matter pertains to costs and not the subject of an order to set aside the order for the AG to intervene as envisaged by clause 4A8, is it not incongruous for the court to consider the public interest rationale for the AG's grounds for intervention at one stage of the proceedings, but not at the point for application of leave to intervene, as is the case under the common law today? So there's an expectation that you can assess the public interest grounds when you look at costs, but earlier on, when, for example, an opposing party applies to intervene to challenge the entry of the AG, the court cannot look into the merits of the public interest grounds. So my suggestion is, number one, isn't that incongruous? To further this point, and this is the point, and I agree with Minister, AG is to act in a non-partisan way, and that is the expectation, and it's important that we record that on the Hansard, I suppose. But in Deepak Sharma, the Court of Appeal also notes the prospect of an adverse court order against the AG, and it's actively contemplated, albeit exceptionally. And there the court says, in cases where the AG has intervened with improper motives, such as to deliberately advance the interests of one of the parties to litigation, that would take the AG out of his capacity as a non-partisan advocate of the public interest and into the shoes of a de facto party to the litigation. And this again aligns with the earlier question I had. If the prospect of an AG acting in a partisan manner can be contemplated at one stage of the proceedings, this is the determination of costs, would the Minister not agree that the courts should be empowered to consider the public interest grounds at the point of the AG's intervention in proceedings? Thank you.
Both questions actually come back to one. Is it two-stage? Is it one stage? Just to be clear, I think what's being done is nothing new. It's a standard process when there is an ex parte application. When there is an ex parte application, the courts hear the party making the ex parte application. It's got to be prima facie. And if on the face of it, it's completely clear that there is no basis, then they will throw it out. But when it moves on to the substantive hearing, these issues will arise in much greater detail. And that's when the court then goes into it in depth. But I think this is fairly standard. It happens all the time, ex parte and then subsequently. For example, the parties can, as I said, can oppose the AG having been added. And they can raise a number of grounds for the AG having been added. After the AG has been added ex parte, the parties can oppose that procedure and the process. And the court will then can consider if such an application is made. And if the court confirms that the AG has been rightly added, then the next step is to deal with the substantive issues and what the point of principle that the AG makes and how it impacts one or the other party's arguments or the outcome itself.
Leader of Opposition.
Share that explanation. I understand the parties can address the ex parte application made by, can oppose the ex parte application, but what the bill...
What I said is that the ex parte application is made, the court makes the order for the Attorney General to be added, but the parties can then subsequently say that shouldn't have been done.
So at the stage where the parties say that shouldn't have been done, what the bill does is to confirm that the court cannot look into the public interest ground in assessing that application. And this is the nub of my concern. So I'm suggesting that in view of the earlier point I made about costs, if the courts can look into the substantive arguments later on, why not just allow them to do so earlier?
I think this simply takes from the principle, Mr. Singh, members will accept. Really, the Attorney General is a senior legal officer, guardian of public interest. If he says that, I'm saying this as a matter of public interest, we don't want an extended argument trying to delay proceedings by the parties by saying whether there is or there is no public interest. It should be dealt with on the more substantive points. And if subsequently the court finds that the Attorney General's case has got no basis or he contributed in the ways that the courts have identified in very, very narrow categories, they have powers to deal with it.
Zulkarnain Abdul Rahim.
Thank you, Mr. Speaker, for allowing me to participate in this debate. Thank you, Minister Shan, for answering the queries that I've made previously and directly to you. I just have one clarification in respect of the documents-only hearing. I agree that it depends on the case, and especially given our current context of a docket system, whether there would be an internal tendency to actually decide on documents-only hearing at the earliest possible opportunity so that we can save much time and cost for the cases. Thank you very much.
I think, as I said, this is a matter that can be taken up with the courts, make the application, and then they will have to make a decision. It's difficult for me to set it out in broad terms today. Thank you.
The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Courts, Civil and Criminal Justice Reform Bill.
Committee stage, what day?
Now, so I beg to move that Parliament will immediately resolve itself into a committee on the bill.
question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 12 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Clause 13, Minister for Law.
Sir, there are two amendments to Clause 13 as indicated in the order paper supplement. As the amendments are related, may I seek your permission to move them together?
Please proceed.
Mr. Speaker, sir, I beg to move that the amendment standing in my name, as indicated in the order paper supplement, be moved. The reasons for the amendment have been explained in the speech by Minister Edwin Tong yesterday.
Question is as proposed by the member. As many as are of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Clause 13 as amended. The question is that Clause 13 as amended stands part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 14 to 24 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Clause 25, Minister for Law.
Mr. Speaker, I beg to move that the amendment standing in my name, as indicated in the order paper supplement, be taken, and again, the reasons for the amendment have been explained yesterday.
The question is as proposed by the member. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Clause 25 as amended. The question is that Clause 25 as amended stands part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 26 to 229 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The consequential amendments to be made will be made. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in the committee and agreed to with amendments.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time. And may I put one matter on record, sir? Number of MPs had raised questions, and even if they didn't speak, I had decided to respond, and that's like Mr. Zul. He had given his points to me, and I had made sure that we have responded on the record. Thank you.
Apologize to Mr. Zul for not calling him. The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Courts, Civil and Criminal Justice Reform Bill.